Hey Democrats! First of all, happy Pride. Today is Manhattan Pride, and we're going to be celebrating that by dedicating our first liberal boot camp for the summer to two major gay rights rulings that we just saw come out of the Supreme Court this week. The first one is about the Defense of Marriage Act, otherwise known as DOMA, in the case Windsor v. USA. The Defense of Marriage Act, as most of you know, was passed 17 years ago by Congress, signed into law by President Bill Clinton, and it was a horribly discriminatory law that defined marriage in the federal government's eyes as being exclusively between a man and a woman. That meant that the federal government could not recognize any same-sex couples or unions or marriages in states where same-sex marriage was legal, which meant that same-sex couples who were married didn't get any of the federal benefits that marriage brings to straight couples, like tax benefits. They couldn't get pension benefits from their spouses in the military. They weren't entitled to know if their spouses in the military had been killed in action. A whole bunch of very serious material consequences, in addition to be treated like their marriages were somehow second class. Well, luckily, DOMA was just struck down by the Supreme Court earlier this week in a case called Windsor v. USA. This case arose when two women, Edie Windsor and Thea Clara Spire, were married several years ago, and unfortunately, Ms. Spire passed away. And her wife, Edie Windsor, was inherited all her money, but then had to pay a $360,000 estate tax that she would otherwise not have had to pay had the federal government recognized that she was a surviving spouse and inheriting that money as a spouse. And so she sued the federal government, saying that she shouldn't have to pay those taxes under the grounds that DOMA is unconstitutional, on the grounds that it is, like I said, horribly discriminatory and violates the Fifth Amendment, which guarantees that people be treated equally under the law. And in a 5-4 decision, the court just announced that DOMA has been struck down. Yay! That means the federal government now recognizes same-sex marriages as being equivalent to any other heterosexual marriage. And that means that same-sex couples are now entitled to all the benefits of marriage, and often very material ones that the heterosexual couples used to get exclusively. So the law's been struck down on on the basis of several different areas of the Constitution. First of all, there's a federal argument. Historically speaking, defining marriage has always been the responsibility of the states. That's why a state gets to decide if they want to legalize same-sex marriage, and other states can decide not to do so, and that's constitutionally acceptable. And the federal government has pretty much never had the chance or the opportunity to do so. And a lot of times this debate doesn't necessarily have to do with same-sex marriages. Actually, it goes far farther back. States have different ages when people are allowed to get married. But historically speaking, the federal government never had that power. And there's the opinion written by Justice Kennedy does, make a point of paying attention to that. He also spends some time on due process concerns, but he does actually spend a very significant part of the decision and justifies his decision to strike down the Defense of Marriage Act on the basis of the Fifth Amendment, which, as I said, guarantees that everyone has equal protection under the law. So I'm just going to read you a really quick excerpt from his decision towards the end. The federal statute is invalid, for no legitimate purpose overcomes the purpose and effect to disparage and injure those whom the states, by its marriage laws, sought to protect in personhood and dignity. So essentially what he's saying there's no federal purpose for having a law like DOMA except to sort of demean and punish people for their moral and sexual choices, and people who the states had in and of themselves chosen to protect in, as he said, their personhood and dignity and their marriage to other men or other women. And so he decided to strike that down because the key problem with the law, in his opinion, was the deprivation of the liberty to people who'd been protected by the states and should have been protected by the Fifth Amendment. And it's very heartening to see an argument based on Fifth Amendment concerns, because that means that we have really good reason to hope for future marriage cases and future gay rights cases going to the states, or going to the Supreme Court, That said, he does rely very, very heavily on the states being the ones to grant that dignity that he wants to protect, and very much on the states being the ones to grant that right. So same-sex marriage is not legal all over the country, but what this decision does mean is that people who have had their marriages recognized in their states, or who've gone to other states where gay marriage is legalized and had their marriages officiated there, are now going to see the exact same benefits as heterosexual couples. and their marriages are no longer going to be second class and treated as such by the federal government. So that was a really, really exciting moment, and it was a really important step forward for the gay rights movement. Another very happy thing that happened on the same day was a ruling on Prop 8, striking down Proposition 8 of California. As you guys, again, probably know, Proposition 8 was a constitutional amendment that was passed by California in California by referendum, banning gay marriages in that state. And that was also struck down by the Supreme Court, but not on the grounds that the proposition itself was unconstitutional. This is where it gets a little bit complicated. What the court actually said, and here it was a 5-4 decision, again, Roberts, Scalia, Ginsburg, Breyer, and Kagan being the majority, not people you normally see, the later three being of the court's liberal wing, the first two very much not, were decided not to say that Prop 8 was unconstitutional, but that the people who are appealing the ruling didn't have standing. Let me explain what that means. To bring a case to the Supreme Court, or really to court in general, you have to have what's called standing, which is a complicated legal word for saying that you have to have some material stake in the issue. So if you're not being harmed by an action, or if someone hasn't harmed you, you can't go to court to protest that. So if I hit you in the face, you're allowed to go to court and say, hey, she hit me in the face, and I deserve some sort of recompense for that. But if I call you a name and you feel kind of bad, that doesn't count as standing or significant harm that's been done to you. So in the same sense, what happened was the Supreme Court decided the people who were defending Prop 8 and who were against same-sex marriage in California didn't have standing to come to the Supreme Court. What had happened was a district court in California had struck down Prop 8 on the grounds that it was unconstitutional, and the Democratic governor of California, Jerry Brown, decided that he and his attorney general didn't want to defend the law in court anymore. They agreed. They didn't think it was constitutional to deny people the right to marry, regardless of their sexual orientation and regardless of who they wanted to marry. So they refused to defend the law in court, and that meant that the people who ended up defending it were people who were religious supporters of Prop 8. Who strongly believed that gay marriage was a bad thing to see in California, and they defended it simply on the grounds that they were representing the people of California who had voted to ban same-sex marriage. And they didn't want to see it go through. They didn't want to see same-sex marriages happen in California, so they decided that in the place of the government, which normally would defend this law, they were going to defend it in court. So they appealed that decision, and the appeals court again decided that Prop 8 was unconstitutional. It's unconstitutional to deny people the right to marry, and that decision went to the Supreme Court. And the Supreme Court, as I said, decided to dismiss the court. The specific phrase they said was they sent it back to the appeals court with, quote-unquote, instructions to dismiss the appeal for lack of jurisdiction. And the reason they did this was the people who were defending Prop 8, because they weren't the government who are normally charged with defending their laws in court, were defending the law Prop 8 because they had what's called a generalized grievance. They thought that gay marriage was bad, and it was bad for the country, and it would kind of, in a general way, harm them if gay people got married in their state, because for some reason their marriages were going to be harmed if other people had happy marriages. And that's not a real significant harm that's done to them. They're not really harmed by other people getting married, and they're not really harmed by same-sex marriage. And so they don't have a right to be in court defending laws against same-sex marriage. So again, the Supreme Court did not say that bans on same-sex marriage are unconstitutional. They didn't say that all states have to mandate same-sex marriage, but they did remand that decision back to the district court. So what that does mean that doesn't mean that the Supreme Court is declaring its support for same-sex marriage, but it does mean that same-sex marriage is legalized in California, which is fantastic, and that means that now approximately 30% of the country lives in places where same-sex marriages are allowed. So that's basically what happened, but before I leave, I'm going to leave you with one extra historical note. The day that these decisions came out was 10 years to the day, the anniversary of Lawrence v. Texas, the decision that struck down long-standing sodomy laws in the country. That meant that 10 years ago, it was illegal in many states for two men to have sex with each other, much less to get married. And in his dissent to Lawrence v. Texas, Justice Scalia stated that, this decision was terrible. It was going to lead to bestiality and crazy things like gay people getting married. And everyone was like, that's crazy, Scalia. That's never going to happen. That's not something that the country would ever accept. And here, 10 years later, we are affirming people's right to get married and to express their love for whoever it is that they want to express that love to. And we're making sure that people are treated equally under the law, regardless of their sexual orientation. So I just want to say it's incredible how much progress we've made in those 10 years. And it's incredible how far this movement has come. So happy Pride. Go out and celebrate. Go out and commemorate the struggles and the victories that the gay rights movement has faced in the last 10 years and in the last 50, 60, 100 years. And thanks so much for listening. Check in next week for our next Level Bootcamp. Thanks.